Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning to everybody. First of all, I would like to welcome all of you to the Innovation and Commercialization Showcase and Seminar 2008. Before we proceed with the opening ceremony, we shall proceed with the speaker first. So I was told by the speaker not to read too much of herself. But first of all, I would like to introduce her. Associate Professor Rohazar Wati binti Zuallcobley is the Deputy Director General, Industrial Property of Intellectual Property Corporation of Malaysia, MyIPO. Prior to joining MyIPO, she was Associate Professor at the Faculty of Law in Maras University of Technology. Today's presentation, she will talk about patent drafting and patent filing process and procedures. And with that, I would like to welcome Professor Madya Rohazar Wati Zuallcobley. Please welcome.
Assalamualaikum warahmatullahi wabarakatuh. So first and foremost, I would like to thank Dr. Gomez for the invitation to participate in today's Innovation and Commercialization Showcase and Seminar 2008. MyIPO would always accept invitation from all the university and from all the SMI who would like more input on intellectual property protection in Malaysia. So I've been asked to do this paper that is patent drafting and patent filing process and procedure. So let's have a look at the patent legal landscape in Malaysia. Since innovation and research talk about the IP ecosystem that is from creation, and then of course from creation you would like protection, from protection of course you would want to commercialize, and you want of course the extraction of value of your innovation. Therefore, we need to look into the patent legal landscape whether the IP law in Malaysia, which is under the custody of MyIPO, do provide such protection. So the patent landscape in Malaysia, if we look at our Patent Act 1983 and our patent regulation, it is canvassed from the international convention that Malaysia is a party. The first one, of course, is the Paris Convention, where it laid down that Malaysia must fulfill the minimum requirement that is there under the Paris Convention regarding patent. And one of the most important article in the Paris Convention concern, of course, the right of priority. That is the 12-month priority period regarding filing, where you can claim an earlier priority. So that is the first one. And of course, you have got TRIPS, that is the agreement on trade-related aspect of intellectual property, as another very important agreement that Malaysia is also a member in 1995. And this also provide the guideline or the basic principle that is there, that is later incorporated into the Patent Act 1983. And to assist Malaysian patent owner, you will see that we also has acceded to the PCT, the Patent Cooperation Treaty. This was done in the year 2006. So there is now a possibility of applying for patent via what we call the Patent Cooperation Treaty. So this allows you to go through an international patent application. Note the word, it is an international patent application. It is not an international patent, okay? So these are the international agreement and treaty that canvass our domestic legislation. There is the Patent Act 1983 and its regulation. And you will see that before the passing of the Patent Act 1983, in Malaysia, for those who wanted to get their patent, then you will have to apply in the UK. Because why? Because under the old legislation, we only grant protection for patent that is granted in the UK. So this act then was enacted and it was passed in 1983 and it came into force in the year 1986. So what is the role of MyIPO? Okay. The Malaysian Intellectual Property Organization, or MyIPO, is the body that was corporatized in the year 2003. So we are actually quite young. We are 5 years old. So we are the body that receive patent application. And also beside patent, we also receive registration for trademark, for industrial design, for GI. There is no registration, of course, for copyright. You get it automatically as we are member of the Berne Convention. So the role of MyIPO with regard to patent application is, of course, to receive the application. And we do examination as to form. I will explain later when we talk about patent application. What does it mean by application as to form? And we do publication of the application as well, 18 months from the filing date. We do examination as to substance. I'll also explain later what is meant by examination as to substance. And of course, at the end of the day, MyIPO then either grant or refuse the patent itself. And for post-grant, we also do maintenance of the patent, meaning that you come back to us and pay your renewal fee. Okay? So let's have a look at the philosophy of the patent system. When we talk about the patent drafting, the topic that I was asked to do is on patent drafting. The philosophy of the patent system is that the state, that is the government, grant the inventor, that is you, the researcher, an exclusive monopoly, meaning that exclusive in the sense, well, from the filing date onwards, if later you are ever granted that patent, well, you get that 20-year monopoly. So that's why it says that it's an exclusive monopoly. Those who come second will not be able to exercise that invention unless it's for their own personal use. But is it forever? No, it's for a limited time. That is 20 years from the date of filing. Okay? But it says that in his invention, in return for his disclosure of the invention. So meaning that you have to disclose your invention where in the description. Okay, so that the public at large will be able to practice the invention once the patent expires. So that is the philosophy of the patent system, meaning that you will get the monopoly, okay, from the government if you are able to disclose in that description that you are required under the Patent Act and the patent regulation to disclose to us what is it about this invention that it will pass the 3-step test regarding patentability. The fact that it is new, and new means this is absolute novelty, meaning that all over the world this is new. And then there is inventive step, meaning that, you know, to a person's skill in the art, okay, what you have got is something that is not anticipated, for example. And of course, there are industrial application, meaning that this patent or this innovation that you have got can be used in any industry. So it has a characteristic with regard to the patent drafting. It has, for example, you need a title, okay? You need to disclose the prior art. You need to tell us what was the history before, and then what is the invention now, therefore comparing to what was before. Now it is actually better. And you have innovated, you have improved. Therefore, what you have put on the market is actually new, okay? And therefore, then once you disclose everything there, and after the substantive examination is done, that you fulfill your part of the contract, that is to tell the government where with this paper, the moment the patent is granted, is open for all to read. And the moment the patent has expired, everybody can then look at this description and practice the patent without having to pay for the monopoly. That's the basic philosophy of the patent system. Okay? It's a contract between the owner and the government You tell us what it's all about, we grant you the monopoly. And then with that monopoly, you have an absolute monopoly to exploit the patent, but at the end of the duration, well, it's then free for all to utilize the innovation. Okay? So therefore, in patent drafting, the role of the description, okay, or the specification, depending on which country you come from. Malaysia, we call it the description. Yeah? The UK, I think they call it the specification. So the role of the description, if you look at the case, Liadet versus Johnson, it says the law in relation to patent require as a price, the individual should pay the people for his monopoly, and then he should enroll to the very best of his knowledge and judgment, the fullest and the most sufficient description of all the particulars on which the effect depended that he was at the time able to do. Meaning that in that description that you submit to our office, you must tell us, for example, what is it all about? I give you this illustration. About 2 years back, okay, one company put into the market a washing machine. Well, the washing machine is old, but the technique that was introduced in this washing machine is that it does not need any detergent for it to be able to give you a clean cycle of clothing. Therefore, you have to then enroll to the very best of your knowledge. What was it? The component of this machine that it doesn't need any washing machine, but any detergent, but still, this washing machine are able to give you clothes that are as clean as without any detergent or with detergent. Okay? So that you disclose. And when we do the substantive check, we say, okay, there was no such machine before, therefore this is new. It's not anticipated by the person skilled in the art that you can have washing machine that don't need soap or detergent at all, for example. Okay, so that it passed inventive step. And can it be used in any industry? The answer, well, of course, definitely. Okay, there you will pass the test of patentability. So that description that you disclose, okay, is then supported, okay, when you do the drafting by the claim, okay. Under the Patent Act, you will see that this claim is one of the most important things that must be there with regard to your patent application. Because why? Because the claim has certain function. That is, the first function is that the claim would limit the boundary of your monopoly. It tells you, for example, okay, this is what you are claiming. Because if you look at the case of turmeric, for example, okay, they claim application of turmeric to an open wound. So the monopoly is that, okay, when you apply turmeric to an open wound, that is the monopoly. So if you apply turmeric to any other thing, there is no monopoly. So that is why we say it's very important for you to then be able to claim correctly. Because claim is something that is important to mark that boundary of what you have got, and also when there is an infringement action. So there are certain guidelines regarding the function of the claim and how it is being interpreted by court, okay? But the gist of it is this. As I mentioned, it limits the boundary of your monopoly. You cannot claim beyond what is there. If you never claim it, then what is not claimed, we say, is disclaimed. For example, you have described it in the description, but you fail to claim it in your claim, there is no monopoly. So if somebody infringe what you describe, but you never claim, then so be it. The law says you never claim it. Therefore, you cannot sue for infringement. And the third guiding principle with regard to the function of the claim is that the claim must relate to the description. Because why? Because remember, when we talk about the philosophy of the patent, is that you disclose, okay, how you come about this invention. And then upon that disclosure, we grant you the monopoly. So if you don't disclose, then there's no way you can claim because you never tell us how it is done. Therefore, the law says claim must relate to the description. If you claim something you do not disclose, then there is also no monopoly because it become invalidated. The claim become invalidated. And the fourth guiding principle is that you cannot claim what is not disclosed in the description. Meaning that you never said anything, okay, but you wanted to claim. So again, okay, that one also will be invalidated. So let's look at the patent filing process because everybody wants to know how do they apply for a patent in Malaysia. You will see that it's up to you. It's a commercial decision how you want to apply for a patent in Malaysia. We give you 3 ways regarding the route to grant. Number 1, if you consider that your innovation, be it this product or this process, is only good to be put in Malaysia, to be commercialized in Malaysia, and that is where you only want the protection, then the best thing is only to apply to MyIPO, the so-called national office, okay, for a national application. But on the other hand, if you would like, for example, to apply to a number of countries, but do not want to use the PCT route, then you can use what we call the Paris route. Meaning that you apply to a few countries, Malaysia, Singapore, for example, and then you claim via the PCT route because you want the 12-month priority period. That could also be done. Or you want to put your product in a number of countries. Meaning that you want to go to Europe, you want to go to Australia, you want to go to US, for example, then we would suggest the best way is to go via the PCT route, the Patent Cooperation Treaty route. Because there, the PCT will allow you to give a better assessment of your innovation. Because the result that is given by the International Searching Authority will tell you whether your application has got what we call a clear report, therefore making it easier for you to go to the second part of this international application, that is the national phase, or if you got what we call an adverse report, then not to go through the national phase at all, because definitely your patent will not be granted. So on the patent filing process, actually it's up to you to determine commercially where you want to put your product. So let's have a look at on submitting an application. Well, it says any person can apply. It can be a juristic person, a company. It can be a natural person, okay? But at MyIPO, we say that you must always name the inventor. Because why? We have this moral protection there under the regulation that if the university submit, they must put in the name of the inventor. Because Section 20 allows the inventor who invent a product under a contract of employment to participate on an equitable remuneration. Should the product later, when it's put on the market, then it got a value that is beyond what was actually anticipated by both parties. This is a particular section that was there under Section 20 to encourage what we call innovation. So that's why the regulation states you must tell us the name of the inventor. If you do not want to put the name of the inventor, give us a statement why the name of the inventor is not there. Okay, so that one is the requirement to protect the moral right of the inventor. And also to make sure that the provision of Section 20, okay, will be taken care of. So let's have a look at the summary of the procedure. Okay, I will explain, okay, briefly, because everybody wants to know why does it take 4.5 years to grant patent. Okay. So, can you look at the flow chart? I hope you are able to have a look at it. It's quite small, isn't it? Okay. This one here, the first flow chart, patent and certificate for utility innovation granting procedure. This one, a summary, briefly, of what actually happened to the application. Because in Malaysia, we grant patent as well as certificate of utility innovation, or the so-called petty patent. Okay. So before we go into the detailed procedure, I would just like to explain briefly. The first thing is that, okay, when you apply, then the applicant must lodge Form 1, that is request for a patent, or Form 14, request for utility innovation. That's the first thing there. You fill in the form, and of course, you pay the prescribed fee. Okay? So there, you must also have got together your description. And if for utility innovation or petty patent, there's only one claim is allowed, okay? And of course, it contains there all the matter in the regulation, the title of the invention for the patent, the prior art, the history, and then what is new, and then of course an abstract. So the moment you submit that, okay, then it says, when it goes to our office, this application request will then be examined to determine the filing date. Okay? Why do we have to examine the filing date? Because that will be your priority date. Because under the Malaysian law, the filing date will be the priority date. Unless, of course, you are claiming an earlier priority. If you have come from Paris, a union country, then the application can then fulfill other formality whereby they will be given the filing date that they have requested. So we look at all the form and everything. If it's done there, fine, you get your filing date. So the next stage, okay, will be what we call a preliminary examination, okay, where we will look at all the document that is actually submitted, whether the physical part of the document is in compliance, for example, okay, all what we call here is a formality check. We don't at all check the content of the patent application. We just look on the formality requirement. If you pass that, we give a report, we say clear formality. If it doesn't, it becomes adverse formality. After this, I'll show you another flow chart where we go a bit detailed. And then if you pass, we give you a letter to say, okay, clear formality. Then what happens is that it's up for you then to request for a substantive examination to be done. Or you might want to ask for a modified substantive examination to be done. Okay? A substantive examination meaning that now you're asking our examiner to do a check on your patent application where we look at the three concepts, okay, that is novelty, inventive step, and then of course industrial application. The whole thing there on novelty, we do a thorough check, and as you know, there are about 65 to 67 million patent documents out there. There are patent documents to be looked into. There are non-patent documents that the examiner has to look into. After all, novelty in Malaysia is absolute novelty, whole world content, we say. So then we also have a look at the industrial application and the inventive concept. So the examiner will conduct the search and examination. After that, it's either grant or refuse. Okay, and if it's granted, you will get 20 years from the date of filing. That's how long the patent application, the patent duration for the monopoly would last. So this one here is the detailed flow chart regarding patent application. So these are the time period that you have to comply with. So if we go back again, the applicant files the application. So then we will do an examination to determine the filing date. If, for example, everything is there, we will grant you a filing date. But if it's not there, certain document is missing, not correct, documentation incorrect, then we'll give it back to you. And then the application are given 3 months to correct. So definitely on that day you file, you do not get the filing date. Okay? But if everything is in order, within 5 days you will get the date, okay, the certificate of filing to grant you the date that you file. At that date that you file, everything is actually in order. So then the applicant, if it doesn't correct our request within the 3-month period, the application are deemed then to be abandoned. Okay. So on application then are deemed correct, it will go to the next stage. Okay. It will be, as I mentioned just now, accorded a filing date. And then the moment that happens, you will see that we'll do what I explained just now, the formality examination, to see that, you know, physical content, everything, drawing is there, okay? So there, this is the preliminary, to do the formality check. If formality is not correct, again, we give you what we call adverse formality. So again, the applicant is given 3 months to correct. You are to correct it back. You don't correct, we consider it abandoned, okay? Meaning that application will be refused at that stage. So if everything goes well, then the moment you get formalities correct, we allow you then to request for a substantive examination, whereby you must come back to the IP office 2 years from the date of filing to request substantive examination. But if you do not want to request within that 2 years, then before the 2 years is up, you can come back to the IP office, okay, and request for what we call a deferment. We give you an additional 3 years to defer. So the total time period will be 5 years. This one, of course, is not extendable, okay, meaning that after 5 years is gone, that's it. There's no way we can then allow to defer anymore this request for what we call substantive examination. But if you don't request, and this is what usually happens, that is why MyIPO, okay, has always asked TLO office to university to have TLO office who have officers who know the procedure for grant. Because why? Because professor, researcher, lecturer who do research in university, they forget the time period. And sometimes 3 years has passed and they never come back and request for substantive examination. So the time is gone, for example. Okay, and they ask for any OT, okay, extension of time. So if, for example, you have asked for a substantive examination, then the examination will be done. And if everything comply with the act, then you get your grant of patent. If, for example, upon the first examination, there are corrections to be made, then we will ask the applicant to comply. And the applicant then given another 3 months to do the correction and to come back to us. Sometimes what happens is that when we do the substantive examination, we found out that, that this application for this patent is a divisional application, meaning that there are 2 innovations in one, okay? So therefore, we ask you to divide the application. Then you will have to divide the application. Or sometimes we ask them to correct because there are certain prior art that was not discussed, it doesn't show novelty or whatnot. Therefore, we give them what we call adverse substantive examination. So we ask them to do any correction if they want. So they have to come back within 3 months to do the correction. We allow at the IP office up to 2 communications, meaning that you have the right to do 2 corrections. If on the second correction, we do another examination, and again, it doesn't fulfill patentability, then definitely will refuse grant of the patent, okay? So the philosophy at the IP office is always to grant rather than not to grant. So that is why you will see that this test there, if, for example, there's nothing there regarding novelty, where it will attack your claim of novelty or inventive step, okay, definitely we will grant the patent. So the moment you comply with the provision of the act, the patent will be granted, and then you will get a certificate. And this is where, after getting the certificate, it doesn't end there. You still have to come back to the IP office, whereby you will have to pay for renewal fee. Okay, this is paid on a yearly basis. If you fail to pay the renewal fee, then we consider the patent to have lapsed. We will then gazette it in the government gazette, and the moment it's lapsed, there will be no monopoly granted. Okay, the monopoly will now be revoked because of non-payment of fee. So just now, that is with regard to the standard procedure. But as I told you, universities sometimes always would like to ask for the right to defer, meaning that you don't want to come back to us within the time period and ask for a substantive examination. You want to defer the period of a substantive examination. Well, there is always the right of deferment, but of course you pay the fee. Okay, the deferment fee will have to be paid. And then you can ask for deferment for both situations. Number 1 there, where you want to request for substantive examination, or where you want to request for what we call a modified substantive examination. I will just explain. A modified substantive examination is where the applicant, besides applying to Malaysia, also has actually applied to US or to Europe or also to Japan. Okay? And then this country had granted you a patent earlier than the IP office in Malaysia. So you come back to us with a copy, okay, of that certificate of grant. And then you request from us not a substantive examination, but a modified substantive examination. Show us the certificate of grant, okay, and then we'll do what we call a top-up examination, meaning that we only look at the patent document that is part of our national application. We do a top-up looking at, what is patentable, non-patentable, what is public interest in Malaysia or moral ground, so that patent may not be granted. So this is what we call a top-up. So those that come in for a modified substantive examination is much faster than a substantive examination. Because why? Because the patent has already been granted elsewhere. But the reason why we allow deferment to a maximum of 5 years, because previously under the old provision before 2006, deferment for modified substantive, okay, was only up to a maximum of 4 years. But then the Japan government, that is the JPO, come back to us and say that, because they keep saying that they grant very fast. So we say, if you grant fast, we got no problem into coming into the IP office within that 4-year period. But then they couldn't come back to the IP office in Malaysia with a certificate because they also grant very late in Japan. So we said, well, the only way now is that for Malaysia to allow an extension of deferment up to a maximum of 5 years. So we are hoping with that maximum, then other grant from other IP office will be able to come back within that period and request for a modified substantive examination. So these are the things that usually happen at the IP office where, as applicant, you would like to know whether you can defer. And the answer is yes, you can always defer request for substantive examination. So just now I mentioned initially, briefly, the PCT. This one is good, as I mentioned just now, if you want to go for what we call the country which is wider compared to just a regional, a few countries around ASEAN. You might want, for example, as I mentioned just now, to go to Europe, to go to US, Australia, New Zealand, for example, then you might want to consider using the PCT. Because right now, there are about 139 countries which is member of the PCT. So these are countries where it allows for this international application to take place for patent. So with regard to procedure to apply, it's much more easier because you apply to MyIPO, and then MyIPO will submit your application to WIPO in Geneva. Then we have designate 3 ISA, International Searching Authority, that is the European Patent Office, the EPO. And then we designate KIPO, the Korean IP Office, okay? And then we also designate IP Australia as the International Searching Authority for Malaysia. And then you decide which is actually cheaper. Right now, EPO is cheaper because EPO gives 75% to individual application. There's a discount there, okay? So you choose the ISA that is going to do you the examination with regard to your application. And then you pay the fee. They will give you the result. It's not fast, okay? We have had the discussion with WIPO. You will get your result on the 28th month of your filing date, okay? It will be given to you. With that, you assess whether now you have got what we call a clear report or an adverse report. If you have an adverse report, then do not go to the national fees because definitely patent will not be granted, okay? But if you have got a clear report, then by all means, then go to the country that you want to ask for a patent, because after all, patent is still granted domestically, meaning by each individual country in the PCT. That's why I said it's not an international patent registration is only an international patent application. So once you get a clear report, okay, you go down the national phase, okay, that is to each individual country, then the national law will come into play. Meaning that if you are going to, for example, to Indonesia, Indonesia require that your patent application there must be translated into the in their language. So you do the translation, okay? So in country where they want translation, it has to be done. You appoint a patent agent where they appear on your behalf to the IP office. If you come back to Malaysia, then you can use the same application. After all, in Malaysia, we receive application in English and also in the national language, both. But it's very rare application is actually submitted in Malay. It's always in English, okay? And then the same examination will follow through. But for MyIPO, for patent application that's coming in via the PCT, we say with regard to the moment they come back after their clear report, we're only going to do again a top-up examination during the national phase. Because we are going to rely on the examination done by the SA and only do a top-up regarding our national patent that is available on our data. And it's not much, about 7,800, okay, that we have got. And then we'll do into provision of patentability under Section 13, and we do regarding the public interest or the moral provision under the Act, and therefore we grant. We promise the government that we are going to grant within 6 months of the patent application coming back to MyIPO on each PCT application. And according to the law, since we are just a member of PCT in 2006, the first examination of this application will come in March 2009. So that is why MyIPO is working very hard right now to clear all the present application that is on our table. So this is where if you are going via the PCT. And it is cheaper if you are going for many countries, if you are going via PCT, because why? Because you have got a good assessment when you get the result of the International Searching Authority, whether what you have got is actually patentable or not patentable. And then there is this post-grant procedure, as I mentioned, and everybody forgot about post-grant procedure because everybody thought that the moment the patent is granted, that's it. You got your monopoly, then people forget to pay the renewal fee. You must know that, you know, as a contract, you must pay us the money. Then we keep granting you the monopoly. You don't pay, the effect of failure is that after 2 years, we'll gazette it as lapsed, and then people can check on the gazette. If the patent had lapsed, they can use the process or produce the product and put on the market. And then you can come back to us, definitely, to ask for reinstatement, okay, of lapsed patent. There will be a penalty to be paid. But for those persons who had utilized the patent based on our gazette, then there is no way you can claim compensation for them because the Act protects these people during the time the patent is actually gazetted as being lapsed. Okay, so that will be the effect of failure regarding post-grant procedure. So that one is briefly how to apply for a patent, okay, and what is the function of the patent drafting in Malaysia regarding why the description is very important and why the claim is very important. And a lot of people keep asking MyIPO, why is it so expensive to apply for a patent in Malaysia? My answer is that the cost of the IP office is not expensive. From the day you apply, we charge 250. Throughout the process that I've shown you just now, okay, for each of the form that come in, until grant, the cost is only 1,050 ringgit. That's it. That's the cost of the IP office, okay? But when you tell me that, you know, we are asked to pay 12,000, 15,000, 30,000, okay, for this application, it is the cost of the patent agent. This person whom you have asked to draft the description and also to draft the claim. Okay, so these are the costs of factor that is not within the control of MyIPO. Okay, our cost is actually very cheap, and we have done a study about cost that has been generated in other IP office or incurred by applicant in other IP office. And the conclusion we found out is that of 100% cost that is incurred by the applicant, only a maximum of 22% is actually the cost of the IP office. Okay, this is where when we look at Europe and other countries. Okay, the rest is cost of the translation, cost of the IP lawyer, cost of the patent agent. Okay, so that one is just to explain cost, because at all meeting, okay, a lot of people are asking MyIPO, you know, that cost is a hindrance regarding applying for a patent. So thank you for for you listening to my brief explanation. I am contactable at MyIPO, Rohazar at myipo.gov.my for those who have still got further query regarding application for a patent, or those who have actually applied for a patent and then found out that the application is stuck somewhere. I also would like to know what are the PI number, because we right now are trying to settle all the application, and out of the 90,000 patent application that we have received, you will see that we had actually settled about 70,000 of this application. The rest has asked, about 11,000 has actually asked for deferment. So right now there's only about 8,000 that MyIPO will still have to settle within this year, because you must know for the last 2 years we have gone into intensive labor regarding trying to settle this patent grant, okay? And we are monitoring the file on a monthly basis to make sure that grant is in time. We promised the government that. So that is why if anybody felt that, you know, the application is stuck somewhere, MyIPO would like to know. Because from our experience, we found out that certain applications are stuck because why? Because the agent do not pay the fee. And when we ask the agent, why don't you pay the fee? They say, well, the inventor never pay us anything, so we also do not pay the IP office. So the IP office won't do anything to that application at all, because the Act say we only do an action based on prescribed fee having been paid. Okay, so thank you so much.
Thank you very much to Professor Madya Rohazawati for her presentation. It is hoped that through this information and lengthy explanation, we'll have a better understanding on the Patent Act and regulations. As our appreciation, I would like to invite Dr. Christy Petros Gomez, the Director of Innovation and Commercialization, Showcase and Research, to give away, to present Dr. Professor Madya Rohazawati a token of appreciation. Thank you, Dr. Gomez, and thank you, Professor Madya Rohazawati.